Hi, I'm Aslam Moolla. I'm a CCMA and Labour Lawyer, and in today's video I'm going to talk to you about constructive dismissal. I get quite a few queries from clients asking me, Aslam, what is a constructive dismissal? How do I go about proving it? Can I take it to the CCMA? This is exactly what we're going to cover in today's video. So let's start off by explaining what is a constructive dismissal. In South African labour law, a constructive dismissal is a form of dismissal where an employee is actually forced to resign from work because the employer made the working conditions intolerable. What does that mean? It means that the working conditions were so unbearable, so difficult for the employee that they had no choice, no other option but to leave work. That's the critical part. Unbearable working conditions. What are examples of unbearable working conditions? What are examples of conditions that would make a person be forced to resign from work? The first is, of course, harassment. If you're being harassed at work verbally, physically, sexually, any form of harassment, that would constitute grounds for you to be forced to resign from work. The second is any kind of bullying. It can be a lot of politics take place at work where people are trying to jockey for positions. And if you've been constantly bullied at work and constantly victimized at work, that would be a ground for you to claim constructive dismissal. Other examples would be being humiliated at work on a constant basis, or being falsely accused of something that you didn't do. So in essence, constructive dismissal is where a person is actually forced to resign from work because of the working conditions that they are being placed under. Now, that brings us to the second part of this video, which is what evidence does a person need to prove a constructive dismissal case at the CCMA? Now, since the employee is actually stating that they have been forced to resign from work, the onus of proof is on the employee to show that the working conditions were bad. So the employee must be able to come up with evidence to prove how bad the working conditions were. Now, if you are an employee watching this video, there are 5 factors that you must consider in order for you to win your constructive dismissal case at the CCMA. 5 factors. The first is, number 1, the working conditions were truly and genuinely intolerable. You must be able to have some kind of evidence, WhatsApp messages, emails, dates, times of incidents, witnesses, anything to prove your case of the working conditions and how bad it was for you. That's the first. The second is, the unbearable working conditions were the cause of your resignation. So in other words, you were not planning to resign. This is what caused you to resign. And the third is, you had no alternative but to resign from work. You had no other choice. That was the only option available to you. Number 4 is that the working conditions actually had taken place at work or during working hours. It didn't take place at the park or the beach or sometime on the weekend. It was during working hours at work. And number 5 is that the employer had the power to stop these bad working conditions for you. So it's very important then to sum up by saying that the working conditions were truly and genuinely bad, number 1, and you had no choice but to resign. That's in essence a constructive dismissal. However, it's critical to get this piece of information in, which is you must first alert the employer regarding your situation before you resign. I always advise my clients to first notify the employer saying, I'm unhappy with the way I'm being treated. Please, can you do something about this? Naturally, if you don't alert the employer and you don't give them an opportunity to fix it, if you go to the CCMA later on, the employer may very well say, I didn't know about this. Nobody told me. Had I known, I would have done something. And that would make your case very weak. So I always advise my clients, please try and alert the employer first. So let's say that you've been victimized at work. You sent a couple of emails to the HR department explaining your situation, and they have not done anything to help you. Then I advise my clients to send a follow-up email warning the employer, if you don't fix this situation, I'm going to file a constructive dismissal claim at the CCMA. And that's the dog barking outside. Please excuse that. If they still ignore you, then you can hand in your letter of resignation, but make sure to say that you're being forced to resign. So let me recap that important part, because you might have got distracted by the dog. Let's say you are being victimized at work. You send emails to the HR department, your manager, supervisor, saying, I'm unhappy with the way I'm being treated. Please, can you do something about it? They ignore it. You then send a follow-up email saying, if you do not assist me now or make the situation better, I'm going to file for constructive dismissal. If they still choose to ignore that, then you hand in your letter of resignation and you make it very clear. In your letter of resignation, you say, I'm resigning because of constructive dismissal and for no other reason. After that, you download a CCMA 711 form. The 711 form is the form that actually refers your case to the CCMA. It's available on the CCMA website. It's called a 7.11 form. If you're unable to access the website or you want a copy, drop us a message and we'll be happy to send that to you. Or if you need specific help in your situation, you're welcome to contact us as well. So in today's video, we've covered what is a constructive dismissal, what are examples of constructive dismissal, how to go about proving it, and how to actually refer your case to the CCMA for constructive dismissal. If you need help in your particular situation, you're welcome to click the link below and book a consultation with us. I look forward to hearing from you soon. Take care. Bye.